she don't contact the state? Oh, okay. Nice. All the forms, the printer. You taking note? Okay. Mr. McElvain, do we have his number?
Oh, he's still on the
No, we need to get him here.
Oh, she got his phone number?
Do we have Mr. McElvain's number?
Yes.
Let's make sure he's been notified. See where he's at. See if he's
You did, okay, we have a question, don't stress yourself out, He's on the elevator.
Oh, okay. What did we do with the note from the foreperson? Did they write down who the foreperson was on the piece of paper?
Should be on the motion.
No, but I mean, did they put it down separately on a different note?
No.
Who the foreperson was?
Oh, yeah, I brought it out to you right at the back.
I didn't
That's
see
the
it.
first note I wrote.
Because it's on that same side of paper?
Yeah,
Oh, okay.
exact same thing, just with his name on the full person.
Okay.
Let's see how Elkins caught that armed robbery guy the other day. Fairmore.
SunTrust.
Yes.
All right, let's come to order. You ready, Madam Court Reporter?
Yes.
Okay. Have a question. Two different names, Katrina Elkins, count 10, Karima Elkins, count 11. Are they the same person? So I'm going to bring them out and instruct them that Katrina Elkins, any objection to me saying Katrina Elkins is a co-defendant and has been severed and is not on trial here, or how do you want me to put it?
The problem that I'm seeing, Your Honor, is not so much with the court's language, but with having allowed the indictment to go out with the names of the co-defendants who are not on trial. You know, the court did in the abstract instruct the jury that the indictment is not evidence. At the same time, it obviously carries some weight to a jury, and now they know that there's 3 other members of my client's family who were charged with criminal misconduct in this case, and we haven't had an opportunity to cross-examine them.
Well, Mr. Goff, for 2 weeks we have been talking about every single one of these individuals.
Not every single one. But nevertheless, I just wanted to
Okay.
renew the objection that we previously had and ask the court,
I'll just tell them
in the
that,
wisdom of Solomon, to find a solution that addresses both issues.
okay?
I think the court's instructions tell them that
Well,
Katrina Elkins is not Katrina Elkins.
I did not read count 10 of the indictment to them, and that it's not on the verdict form. And I'll just tell them that Katrina Elkins is not on trial in this case. It's not for their consideration.
We understand the ruling of the court. There is two or two other matters that we would,
Different person, yeah. But you could say that it's a different person as well. I think.
Okay?
Your Honor, there are two other matters that need to be taken up. We would really feel more comfortable getting them on the record before the jury returns a verdict. We have a motion for mistrial to make, and on the conclusion of that motion for mistrial, we would like to renew the other 9 that are pending, and get those on the record.
Okay, can we do that? Let's go ahead and bring the jury back. Let me instruct them as this, and then while we're here on the record, you can
Yes.
put that on the record. Okay, so I'll rise for the jury.
All rise for the jury.
Everyone to get off and vote here. Okay. Mr. Foster?
Yes.
Okay. You are a foreperson?
Yes, sir.
Okay. I have a note, 2 different names, Katrina Elkins, count 10, and Karima Elkins, count 11. Are they the same person? The court here instructs you that Katrina Elkins is a different person and is not on trial in this case. Okay?
Okay.
All right. Those instructions, I'll let you continue deliberations. All right. Both needs to be filed with the clerk.
Be seated, please.
May I proceed, Your Honor?
Okay?
Your Honor, at this time, we would make a motion for mistrial based on jury tampering. Your Honor, it was brought to our attention by the court, I believe, yesterday or the day before, that there was a communication that was made to a juror during the trial of this case, after the jurors were sworn and prior to the return of the verdict, during which an individual violated criminal statute 1610-10-97, intimidation or obstruction of jurors. Your Honor, the statute provides very clearly under subsection A that any person who by threat or force or by any threatening action, letter, or communication endeavors to intimidate or impede any trial juror in any court of this state or any court of this county or municipality or any officer may be serving in any such proceeding in any such court while in the discharge of such juror's duties commits shall upon conviction thereof be punishable by a fine of not more than $5,000 or by imprisonment for not more than 20 years or both. Your Honor, and it's our understanding in this case that during the trial of this case, an employer contacted a juror who I will not, well, I guess for the record, we probably need to get it on the record, Your Honor.
I'll put it on the record, but later, but it's, let's say Juror A at this time.
We'll say Juror A was contacted by her employer, his or her employer, and notified that they were fired because of their service on the jury and resulting inability to appear for work, Your Honor. Independently of the criminal statute, I believe somewhere in Title 15 there is a provision which makes it unlawful to fire or punish a juror on account of jury service. Independently, the criminal statute prohibits communications that would interfere with their deliberations. Your Honor, in this case, we're entitled to a mistrial based on this criminal misconduct. It's our understanding, although we've never received a full or final report, and it may be that the court is still, or its officers are still investigating that. We don't know. But from what we do know, the juror was extremely upset and distraught over the situation, and understandably so. And our concern is not just that that juror will now be or may be prejudiced against our client, on whose account they have apparently lost their job. Not just that, but inevitably, if the juror was having a strong emotional reaction, and an understandable one, it's hard to imagine that that emotional response and that reaction did not get translated or passed along to the other jurors, Your Honor. And as far as we can tell, we now have a panel of 12 people who are all going to be blaming our client for the misfortune inflicted upon this person. And constitutionally, under the Sixth Amendment right to jury trial and the Fifth Amendment right to due process under the U.S. Constitution and the parallel provisions under Article I, Section 1 of the Georgia Constitution, as well as other statutory and jurisprudential authority, we believe that Mr. Elkins is entitled to a mistrial at this time. In the alternative, should the court find that there's not an adequate factual basis for that motion, we would ask that the court or its officers provide the information so that we can make an adequate proffer for the record, or in the alternative, conduct a hearing with the affected juror and jurors and employer, so that we will have a clear record for appeal as to the impact of this criminal activity upon the trial of this case. I can't think of anything more offensive to our system of justice than for someone to knowingly and deliberately contact a juror in the middle of the trial of a case and punish them on account of their jury service. There's just no way that doesn't come back to the detriment of Mr. Elkins.
Agreement on joining that motion, Your Honor. It's our understanding, what the court said at sidebar, that the juror was distraught, and it did disrupt the trial, and there was a long break that we had to take so the person could be able to sit and hear the evidence, and you know, I can't think that she wasn't still thinking about the fact she was fired at that time. So in any case, we would join in the motion.
The statute that you're referring to is not Title 15, it's Title 34, 34-1-3, which is the Labor Industrial Relations Code section. Makes it unlawful. That portion is not a criminal act, but just a civil action. The court has taken no action without, and was not going to take any action, since it's just a civil action that it creates, a private civil action on behalf of the juror. So this court has not taken any action in that regard, and would not without the concurrence of the state and the defense. Motion for mistrial is denied. The court may consider, if necessary at the appropriate time, counsel may wish to, may have a right to inquire from the juror if this caused any kind of any kind of prejudice or harm, but the court observed this. Court, when observed the juror, she was upset about it, but indicated she was fine with continuing on with the trial. So the court took the juror at its word, and we proceeded on. Break was probably 10 minutes.
Thank you, Your Honor.
All right, anything further?
Yes, Your Honor. Your Honor, at this time, we would renew the other 9 motions for mistrial. I'll defer to Mr. Lockwood on placing us back on the record in his usual eloquent manner.
Any other motions for mistrial? That one would have been the 9th.
Go ahead.
First was the Bruton issue with respect to Karima Elkins' statement about giving an alibi or a false alibi. The second was Dominique Lang and the polygraph issue, his improper bolstering. The third was the criminal juvenile record, which was a question asked by an attorney. The fourth was R.G. Brooks pleading the fifth. Fifth was the state impermissibly attempting to elicit improper expert testimony. I believe it was referenced as hoodoo scientific testimony during the trial. The next was the challenge to the jury panel that was shown to Mr. Elkins. The seventh was based upon Mr. Economo's facial expressions, and the eighth was based upon Mr. Economo's comments during the case.
How many was that, Your Honor?
Pardon me?
How many was that? How many motions was
They claimed 9. I wasn't counting.
That was 8, and the one Mr. Goff raised would have been the 9th, and we'd also renew our motions for directed verdict at this time as well.
Now, these 9, now Mr. Goff had referred to his inchoate motion for new trial. Has that now been actualized into number 9, or is it still inchoate?
It has now been actualized. It is no longer inchoate.
So we don't have any inchoate motions for mistrial out there that the court might need to...
And I will, you wish to say anything else?
No, I just want to be sure that all motions that were inchoate have now been actualized and are in existence so that we have a correct count. And so, you know.
All right. As to the, I ruled as to Mr. Goff's motion, and that has now been actualized, and as to the other 8, my ruling remains the same, and you noted for the record.
And if I might point out, in connection with the 9th motion for mistrial, for the court's, the state concurs with the court's ruling on that, but Professor Carlson has reminded me of the fact of the case of Doyle versus State, 70 Georgia 134, 1883, and Supple, S-U-P-L-E versus State 133 Georgia 601 in 1909. It has been the law in Georgia for over 100 years that communication of a juror with a third person, nothing more than remarks which may be a mere irregularity, is not cause for a new trial. So even assuming this man improperly, and perhaps with some civil liability, communicated with his employee, it would not be a basis for a motion for a new trial.
I will state on the record that bailiff, apparently this juror A commented to the bailiff this morning on the way in, the matter is resolved. It's no longer an issue.
Oh, thank you, Your Honor.
And so it may have been because my understanding is the news media reported this yesterday, and so it may have been informally communicated. So
now, would that cause? I just want the record to be clear. Does that mean that, based upon what the court said, that the defense is withdrawing motion for mistrial number 9?
No, Your Honor. Resolving it 3 days, 2 or 3 days after it happened, doesn't solve the problem.
So that motion remains made and denied by the court?
it does.
Okay.
All right, we have a new question since y'all are out here.
Oh, well,
Can we have a written copy of the judge's instructions?
we have no objection.
We want to review specifically the instructions for count 11, signed by the foreperson. All right, we have a clean copy. My copy is not clean, but we need to take out the two sentences that I,
Subject to the removal of those that would not apply, the state has no objection with the charges going to the jury.
to the,
Oh, the two.
that doesn't apply, that I caught as I was reading it.
No objection.
This, the copy that, when I get it, the clean copy of the judge's charge, I'll mark it as Court Exhibit 1, and it'll be made part of the record when it comes back. It's not an exhibit, just part of the record. No, not an exhibit. I'm not marking it as an exhibit, I'm just making it part of the record. All right, we'll be in recess till we hear from the jury.
You want to check out how it went? Yeah. I think I'm sleeping overnight.
It was Northeast. The judge